the basic. So let's start with the really simple question. Who are you and why should we listen to you? I am a graduate of Baylor University. I have a BA in psychology, and I went to Southern Methodist University, Denman School of Law in Texas. I am Texas-based. When I first started practicing law, I was working in the foster care system. I represented children in the system and their best interest. So I loved it, and I thought once I have kids, I'll go back. I had kids, and my first child is autistic. And we went through special education. We lasted till second grade, and it was just not a good fit. It was not working. We pulled him out. And through that experience, I met a lot of families, and I was very aware that a lot of parents don't know their basic rights. And so once my kid was in a great place, I came back into practicing, and I decided to do special education law. It's just another way to help advocate for children. So I'm going to do a little something different. Usually you get the advocacy tips at the end, but I know the law can be a little boring, and I don't want to bore you and then you miss the really important parts. And also, before we begin, I'm doing the federal law. So I'm going to focus on the IDEA. But state law really hones in a lot of that information. So as we're going through, understand I'm giving you the basic, like bare bones, and you need to be going back and figuring out the state law that applies. And I'll point out throughout the presentation moments when I've noticed, what we do in Texas.
There's the iPad.
So advocacy tips. Whether your child is in special ed already, or if they're about to, or you're thinking about putting them in, jump at the beginning signs of issues. A lot of parents will wait and work with teachers, work with the school, and they'll get into these very complicated situations. When you see a problem, start documenting, start advocating. And then ask for an ARD. If you're not already in special education, we'll walk through how to get into special education. If you're already in special education, and I apologize, I keep calling it an ARD. It's an ARD meeting in Texas. It's an IEP meeting everywhere else. So if I call it an ARD, I mean an IEP meeting. It's just a habit. So if you're asking for help or changes, call an IEP meeting. If the schools are promising you things they're going to do, and they don't do them, if it's not in the IEP, it is not legally binding. It's binding. So you're going to be very frustrated because you're going to be like, we said for months the teacher was going to do this, and they never did it. It's not in the IEP. It shows that they knew there's a problem, and we can have an argument about that, but it needs to be in the IEP to really get it done. And you don't want to be in the situation where you have a problem like that. Be prepared when you go to your IEP meetings. Write it down. I get it. I get emotional about my own child. So write down your list of concerns. Come in with solutions. A lot of times you're hitting these brick walls because your school doesn't know or doesn't think outside the box, and they're at a loss. So if you can come in with some of those solutions, and a really good way to do that is bringing a private providers into the school. And set a collaborative tone. So many parents come in with the big emotions, and a lot of trainings will be like, you got to come in like a bulldog, you got to be really aggressive. No, you don't. You can come in and be assertive and firm, but also with a collaborative tone, because you're going to be with these same people for years. And you want to be able to fix it at the IEP table. Always ask why when you go to IEP meetings. If people are like telling you no, or they're just running through things you don't understand, ask them questions, make them explain. They have to explain it to you. In Texas, we have one-party consent for recording conversations. So I always advise my clients that as long as you're in the room, you're allowed to record your meetings. check your state law. Your state law will tell you what the requirements are. Sometimes it is a two-party requirement. So two-party consent requirement. Even if it's only a one-party consent, I would say we're recording. And then the school starts recording. And then it becomes part of the kid's educational record, which is great. You want that. But again, check your state's law. Don't just start recording. Like I said, if your child is a private provider, involve them in the school. Have them sign a release, have your speech therapist talk to the school speech therapist. The more people collaborating, the more people problem solving. Think in terms of skill deficits. A lot of times teachers will say, well, she or he just won't do it. They won't do it. No, it's not that they won't, that they can't yet. So what can we do to get that skill? It's a lot of skill deficits you're going to see because they're not learning the way typical children learn. And sometimes you have to be a lot more intentional with things that you may be shocked about. So really, really think in terms of skill deficits. Document, document, document. So many times parents will call me and I'll be like, send me your most recent IEP, send me your recent FIE, the full individual evaluation, and they have not kept any of it. It's really hard nowadays because everything is sent via email, right? So you get the chance to look at it and then you forget to download it. Download it ahead of time. Write down conversation, write down incidents, have a notebook, or, you know, if you want to do it on your phone, if you want to do it on your computer, just start compiling information. Because again, you're going to be emotional and you're going to want to, having the most rational approach is to write it down. Even when you go to IEP meetings, if you're not recording, write it down. And here's the harsh reality. Unfortunately, children in special education are only entitled to the Chevy, not the Cadillac. So you are entitled to certain things through the law, but you're not entitled to the best version of that necessarily. You can ask, always ask, but you can't dictate necessarily the version of what you're going to get. And like I said, always ask. The worst thing they can say is no. And then you have a documented no on the record in an IEP meeting. Make sure it's an IEP meeting. The goal is to fix it at IEP. And schools want that too. They don't want to keep paying their lawyer. So really being collaborative is key. So I'm going to get into the law. I like talking about the historical context because I think it's important to understand how recent all of the special education actually is. In 1972, there was a congressional investigation and it found there was 8 million disabled children, and I'll let you guys go through the rest of that information, but the key thing is out of all those children, 1.75 million were not receiving education services, which is shocking because you don't think 1972 is so long ago. And we did not have special ed until 1975 and from the Education for All Handicapped Children Act, which is now the IDEA. And I look at it this way, I was born in 1978, so I'm 46 years young, and we're about the same age, me and special education, right? So as I'm growing and the years go by, I'm learning, I'm getting better, I'm maybe some setbacks, but I'm going forward, right? And so with such a young thing as special education, it's not going to be ideal, and your job is to help push it, right? Like my friends help push me to be better. You are going to help push special education to be better. The relevant laws, the IDA, and also along with it is the 35 CFR, and what the number? It's the federal regulations. And the federal regulations really go in and to have a little more detail than the IDEA itself. Like I said in the beginning, state law is really important. Make sure you're looking up your state law. It will modify a lot of things. There's the Rehabilitative Act of 1973, and that's where Section 504 comes from. And you have the ADA as well, and that's anti-discrimination. FERPA, the Family Education Rights and Privacy Act, is important because that's how you get your rights to inspect and review your educational records. But also privacy is part of that. Ooh. So 504 basics, I'm not going to go into the 504 plans because a lot of it is similar to what IDEA does. But 504 basics, all you have to know is it's any physical or mental impairment that substantially limits major life activities. So any of the ing activities, walking, talking, eating, these a lot of times you'll find the kids with asthma or the kids with allergies, ADHD kids are placed under 504 plans. It's not a high standard. The meetings are not as complicated as an IEP meeting. The key takeaways, if you fall under IDEA, then you also fall under 504. So you're getting these same protections. It's equal access. So a lot of the times you can have arguments about, say, school has aftercare programs through the district. And you have a child with a disability, they have to provide equal access to your child to attend. And that's a 504 argument. The ability to participate fully with their peers and to give them accommodation. So I like this little picture because it really shows what accommodation is. It's putting everybody on equal playing field. The Individuals with Disabilities Education Act, IDA, IDEA, or IDEA. Some people call it IDEA. So you're going to hear it kind of different ways from different people. The big takeaways from this act are children with eligible disabilities, and we'll get into what eligible disabilities are guaranteed a free, appropriate public education, which we call FAPE, tailored to meet their unique needs in the least restrictive environment, the LRE. We use a lot of acronyms in special education. It's very easy to Google and find a list of the acronyms. And if you're sitting in an IEP meeting and they're using acronyms, you have no idea what they're talking about, make them explain it to you. So how do you fall under IDA? Well, first and foremost, there's a child find duty that districts are held to, where they have to find kids in their district who they have to identify, locate, and evaluate all the children in their district that that could possibly fall under IDA eligibility. And part of this you'll see in private schools, they'll have signs that will say, does your child have any disabilities? Contact the local district. If their kid's in the school, then, bad grades, behavior, obvious social deficits, they should be flagging. And as you, prior to getting into special education, if you're hearing a lot of this, start documenting it, and we can find a child find violation, they should have caught it sooner. It's an active process. So once the child find happens, or a parent makes a request for special education, this is the timeline of initial referral. This is the federal guideline. Check your state law for modifications because, as you can see, it's very vague. It's a reasonable time. FIE has to be completed in 60 days. Everything else is reasonable time. In Texas, parent request is 15 days, 15 school days. FIE is 45 school days. IEP meeting must be 30 calendar days. And prior written notice has to be given within, or implementation of the IEP is in 5 days after our IEP meeting. So as you can see, each state has their own, and the IDA kind of leaves it very open. So check your state law. If you have an outside diagnosis and your kid's really, really struggling, this process will take a very long time. You're going to be frustrated. A lot of people get frustrated and they're like, why is it taking so long? They're just, they're doing it on purpose or being rude. No, the law allows it. It's frustrating for everyone. So if they have an outside diagnosis, then you can ask for a 504 plan in the meantime, which is much easier to get. And even without an outside diagnosis, depending on what it is, you could get a 504 plan. And you get accommodations, you'll get some things. You're not going to get the full meat of a special education plan, but it's something. And you want something over nothing. So what is the IEP team meeting? It happens at least once a year. You're going to read the IEP once a year. And you're going to revise if necessary. And it most likely will be revised. Really, really important. Parents can request an IEP meeting anytime. You do not have to wait for the school to do it, nor do you have to wait for your annual. You can do it at any time to address your child's educational needs. So that's when I said in the very beginning, if you're having issues, don't call a conference with the teacher necessarily or the conference with the principal. You're not going to get what you need out of it. You need to call an ARD, an IEP meeting. Sorry. So you're going to have a FIE, or evaluation to qualify for special education. And then you do a reevaluation every 3 years to make sure you're still qualifying. You don't necessarily have to do a full evaluation. They'll do a read, which is a review of existing evaluation data. And then it'll have like observations and test scores and all of like the existing data just over the past year or past 3 years. And what you're going to do is after you go through that read, you decide if you need to actually do formal or informal assessments to further pursue anything that's coming up. Who are the members of the IEP team? Parents, gen ed teacher, special ed teacher, district representative, individuals who can interpret evals and data, and discretionary members. So district can bring somebody or a parent can bring somebody with special knowledge of the child or have expertise in an area regarding the child. And sometimes children are part of the IEP, especially when they hit transition age, which federal law says 16. In Texas, it's 14. Again, go back to state law. Or when they're adult age. This is very important. When they turn 18, they are in charge. So if you have a child that has a severe disability and they need extra help to make decisions, this is when you got to be thinking of like guardianship, and you're not thinking of guardianship when they turn 18. You're thinking of guardianship when they turn 15, depending on how hard it is to get it in your state, or supported decision making. They're allowed, even if you don't have those documents, they can allow you to be in the room, but you don't have the power. And I've found so many families, unfortunately, who are in a situation where their child with intellectual disabilities, is of a manner that will be like, well, you didn't let me have chicken nuggets last night. You can't come to ARD. You can't come to IEP. And then they're advocating for themselves. So really careful about these things. A lot of people don't know about, for whatever reason, we just don't have that resources out there that are telling parents once your kids are turning 16 or 14, you really need to be thinking about their future. And that's one of the big things, something I really want you guys to take away from today. You can excuse members. It's a mutually agreed upon excuse, or if they need to leave, everybody has to agree. So gen ed teacher, special ed teacher, district representative, an individual evaluating the data can leave. However, you have to all agree to it, and it has to be in writing. Notice requirements. There's 2 big notice requirements that are part of the IDA. So you're done with your IEP, and they want to implement it. They write a prior written notice. It's very confusing for people what a prior written notice is, because it sounds like you're supposed to get it before the IEP meeting. No, it is the very end, and is basically going to talk about what was proposed, accepted, and rejected, and kind of an explanation of what happened. It's like the cliff notes of what happened at the IEP meeting. it's called a prior written notice because it's you have to get it before prior to the IEP being implemented. And like I said, there is a federal regulation for it, but also look at your state law because the language, again, timelines for when you need that is different from state to state. The other big notice requirement are your procedural safeguards. Those are basically your rights and your child's rights, including conflict resolution. There's FedReg. Also, state law will change what's in those procedural safeguards. You have to be given it once a year minimum. And then here's a list of times when they also have to give it to you. They usually will ask you at the IEP meeting, have you received your procedural safeguards? And that's a great thing to read. It provides you what your rights are. A lot of people don't read them because they're intimidating. I remember getting a stack of papers this big, and being like, somewhere in there is my rights for my child when he was 3. And I as a lawyer didn't read them because I was emotionally overwhelmed. So I get not reading them, but eventually you got to do it. Parental consent. There's a couple of times when you really need to know when you really have to give consent and people get caught up in the language. I wanted to go over these. You have to be fully informed. So you really need to understand what is being done and what is being and what's being proposed and what's going to happen, what you're agreeing to. Let's say that. And it needs to be in writing. Okay. So there's 2 consents during the initial process. There's a consent to the evaluation. If you refuse to consent to the initial evaluation, the district can file due process. They do not necessarily have to. It's discretionary based on your state law, though, too. So a due process complaint is they're going to go before a hearing officer and say that you wouldn't allow them to evaluate the child. It's not a reason. They don't have to do it, and you don't have to be scared of saying no, but be aware that's a possibility. If the child isn't enrolled yet in the district, then they can't file that due process. The second consent that's important for y'all to know is the consent to initial provision of special education related services. This is one that's very confusing and sometimes very handled wrongly by the districts. So you're in IEP meeting, they read the FIE and they find the child eligible for special education. So you've already consented for the eval, you read the eval, it qualifies for special education. Then they have to ask you if you consent to the initial provision of special education and related service. Basically, will you consent to being part of your child being part of special education? It is not specific for the IEP. It is just for getting into special education. Parents get confused because they're like, I'm not consenting to anything until, I look at the IEP, and it's a separate thing. You don't consent to IEPs, you agree to them. So eligibility categories, I'm not going to read through all of them. This is very important to know that the federal regulations define them, but also state law can modify them. Like, for example, this federal eligibility of emotional disturbance in Texas is now called emotional disability. To me, that matters. I think that's a much better, kinder way of discussing emotional disabilities. So just look at what your state has for eligibility and also what the definitions are, because they are not medical definitions. They are educational based definitions. Basics about eligibility, it's a disability, plus you have to demonstrate an educational need due to that disability. So it's not that automatically if your child has autism, they get to be in special ed. No, if they don't have an educational need, then they don't qualify. They'll qualify probably for a 504 for some accommodations, but they're not gonna get an IEP. The ages are from 3 to 21. And you were thinking 18, you graduate. Well, depends on your graduation track. Depends on your child and transition services, which is a whole other like 3-hour lecture. So if your child is entering that going into high school age, you need to be seeking out transition services. One from the district, but also seeking out trainings. The key takeaways, it's not a medical diagnosis. People will hype you up, your doctor will hype you up. No, not a medical diagnosis. Once your child is found eligible under any category, all their educational needs can be addressed regardless of the origin of that need. So say your child has autism, but doesn't qualify for under autism, but they qualify under specific learning disability. If they're showing some lacking in social goals or pragmatic skills, then they can get that help because they are in special education and there are deficits that need to be addressed that are influencing and disturbing their educational needs, or they're getting their education. Components of an IEP. I'm not going to go through all of it. They're pretty basic. Here's what I think is really important. It is very scary to read the IEP. It is daunting. It is very big. There are a lot of words. Read all the words. I just got my child's FIE and he's got an ARD next week. I'm gonna get his draft IEP, and I'm old school. I print it, I get my colored pens, I get my highlighter, and then I just start treating it like I'm studying back in school. I'm gonna dissect it, I'm gonna pull out what I don't understand this and get my questions off of it. And then the same thing when I get his IEP. Read every word and then really ask them, explain it to me if you don't understand. Bare minimum, take the previous year's annual IEP and compare it to the new one. You will be shocked sometimes how little changes happen, especially if they think you're not looking. Not all districts do it. Some districts are great, but depending on your district, I've seen really present levels are supposed to be present levels. What's happening right now? Nope. Copy and paste from the year before. Your goals are to be written based on what your present levels are. How can you know if those goals are accurate if the present levels aren't current? Goals are really hard to read. I can spot a bad one. I don't know how to fix it. I call in people, the experts I know to read them and fix them for me. But again, how does it compare to last year's? And if it sounds weird, ask questions. I'm gonna repeat that 100 times. Ask questions. So these are more of those components. Least restrictive environment. So this is where the parents can get really up in arms because they want their kids in gen ed. There's a spectrum to it, and you don't have to be fully always in gen ed. You have to think about what your kids' needs are, right? And you can start off in gen ed and then realize, hey, for these core curriculum, we need to be pulled out. But they need to be, for the maximum extent appropriate, each child should be with their non-disabled peers. You have to think in terms of, well, if they're trying to move my child, have they done everything in that setting to make that setting work? And that's usually where the failure falls in. I always say schools are fine if you're quietly not learning, but if you're loudly not learning, they have to start getting upset and they want to move you. The quickest answer to that is, have you done a functional behavior assessment? If there's consistent problems, where's the behavior intervention plan? We're going to talk about that because those are the majority of my clients. There's case law that's really relevant to it. It's different across the country. State law is relevant. So again, you're going to have to do that research locally. Related services, there's so many. Everybody thinks about the basic ones. There's so many. So you can Google list for related services. Your biggest thing you got to do is check the frequency, the duration. Is it direct or is it consult? Consult means the speech therapist is not working with your child directly. They're going to go talk to the teacher, give the teacher some pointers and check in with the teacher. And the teacher's going to implement whatever needs to be implemented. So watch that because parents will be like, oh, my child's getting these services. No, they're getting consult. And if it's a group or individual, I found out the hard way that my child was going to 20 minutes of speech every week with 3 other kids. How he was getting speech therapy with 3 other kids for 20 minutes a week, I don't know how that effective that would be, but I didn't know. I mean, I'm a parent with a law degree and I trusted the school. So those are things you check that are easy things to check. What is a free and appropriate public education? The standard has changed. It was really more than de minimis before, and now under Andrew F., which was a Supreme Court case. It's a great Supreme Court case. I don't like reading Supreme Court cases. This is an easy one to read. I think it's an important one to read. It also refers to Raleigh, which is the former standard case. Also really great to read if you want to really understand the history and the mentality and the thought process that went into all of this. It was founded it occurred in 2017. Your takeaway from this, the bare minimum, is 2017 is when we raised the standard. There are a lot of teachers, administrators currently in place right now who were there before we raised the standard. So the mindset is kind of like what you're going to be watching for. Is it reasonably calculated in light of my child's circumstances? Challenging objectives. It's important to know that that's who you're dealing with, people who are coming in with who have been working under a different mindset, and that's possibly why you're getting some backlash. When do you implement the IEP? So you've ended the IEP, you've gotten to the end of the IEP. Do you agree? Do you not agree? Most of the time, you need to read your document. So you're going to say, I don't agree until I see a written copy of the IEP and the prior written notice. Your state will have its own like timeline for this. There's a rare occasion where you're going to have a minimal change, like you just called an artist, a parent, hey, can we add some accommodations? Can we talk about this issue that's coming up? And you change 3 things, you all talked about it, and you're like, I want to start tomorrow. I'm going to go ahead and agree. And you're going to walk away, and they'll implement the IEP as soon as possible, depending on your state's laws. But don't sign anything till you read it. See it in your hand, dissect it, get your highlighter and pens out. And don't agree until you read it for the most part. If you disagree about an eval, you can ask for an IEE, which is an independent educational eval. It is at the district's expense. The head of special education is the one who will make that decision. So you email them. Typically they're going to agree, because if they disagree with you and don't want to do it, they have to file due process. And nobody wants to spend extra money. You're going to spend more they're going to spend more money on the lawyer than on letting you get an IEE. They'll give you the regulations of how to do it, and it's usually very easy to comply with. Conflict resolution, if you're having issues with your district, mediation is great. You don't have to file due process. You can do it with or without due process complaint filed. And it will honestly be the best tool you have to get as much as you can get from the district. And you can also get possibly get attorney's fees, negotiate for that. There's district grievances that you can file based on, they have a list on the school board or the school district's website. You pull it up, find it, and fill out the forms, and there's different levels to it. OCR complaints for 504 and 88 violations. Let's say Office of Civil Rights under the Department of Education. So with everything going on, the Department of Education, from what I understand, some of those OCR complaints may be frozen right now. You can still do it. You can go ahead and apply for them. It'll explain what you can ask for. what violations, and then there's state complaints with your state agency. And again, your state agency will explain what you're allowed to be filing for. When all else fails, you're going to file a due process complaint. Do this with a lawyer. And I've had families call me who have done it without me and be like, I already filed and we're going to due process. I don't really I'm not comfortable doing that. I want to be able to know that what I've taken on is a valid due process. And not to say the parents couldn't do it right. But I think most attorneys want to kind of have their hand in it. The basics. I'm trying to save some time here. So you can read through them. Your state will have its own rules again. What you get out of mediation, what you get out of due process is called compensatory services. When you win at due process, your relief is a form of future conduct, reimbursement orders, or compensatory services. You're not getting damaged. You're not going to be like, I'm going to teach them a lesson through this. You're not. You're going to get whatever is necessary to bring your child back to where they should be had they provided FAPE from the beginning. And it's not a tit for tat necessarily. It's kind of a qualitative analysis. There's no formula. So at mediation, you can get a lot more than a hearing officer. We are not winning, parents are not winning a lot at due process. So you want to go to mediation and you want to solve it. Districts also don't want to have to fight due process. It's expensive. Behavior is communication. Behavior is communication. Behavior is communication. If your child is having behavior issues at school, it is communication. You get a functional behavior assessment for consistent behaviors. They create a behavior intervention plan. Look deeper, think harder. Kids aren't bad. Kids are acting out for a reason. Is there an unidentified disability? Are their needs not being met? Are they being bullied? You take anything away from here. Behavior is communication. So, like my child, every time he read, would have a little tantrum. He just really struggles to read. And he's not being bad. He's not being difficult. It's hard for him. So even if he can read, it's 10 times more effort. You got to think of it that way. You cannot just be like, well, why won't you do this at school? Why are you behaving? There's something going on. This is manifestation determination reviews. It's if they try to discipline your child by taking them out of placement over 10 days. It is a whole big thing. You have to really know the law on this. I've kind of put in some of the information, but again, looking at your state law, the Texas Education Agency hands this out as the discipline flow chart for kids with disabilities. As you can see, highly complicated. So I think when your kid is starting to have behaviors, it's something you really need to tackle ahead of time. Teachers can file charges. You don't want a kid who's hitting at 6 to be hitting at 13. That is a different level of damage. So you need to be on top of it, and you need to be making the school on top of it and aware that this is part of their disability and why they're doing it. So being proactive on this is really important. A lot of my clients are coming to me with discipline, as well as with juvenile charges. So be wary of that. Resources, here's some resources throughout this country. One of the really interesting places to go is the LRP publications. Those are books and trainings written for school admin and school lawyers. So it's hearing their perspective. And they're really well written. As I was doing this presentation, I pulled out my book because I was like, I'm used to doing Texas law, and I wanted to make sure I was only talking federal law. COPA is a great organization as well. And Google is not always your friend. Find reliable sources. Find people who are collaborative and who want to help make it better not come in and be a bull in a china shop. There's a time and a place for that. But if you're emotional, you don't want the person you hire, your advocate or your attorney, to be emotional. You want them to be the neutral person in the room that's come to problem solve. Not neutral, let me take it back. Neutral tone. But can problem solve and kind of help you figure it out. And if then we need to, we can go to war. I understand wanting to burn it all down to the ground. Absolutely. But that isn't the initial starting point. I'll leave you with a Ted Lasso quote because I'm a big fan. Taking on a challenge is a lot like riding a horse. If you're comfortable while you're doing it wrong. So you're going to be real uncomfortable, guys. Once you start learning a lot about your advocacy rights, your child's rights, and coming into these meetings and pointing things out and having conversations that are sometimes really uncomfortable, but you have the right to ask questions and you have the right to advocate. So do so, and I think you're going to learn that your child will get a lot better care when they know that you're a savvy parent. So thank you. We can open to questions. That's my email address. Like I said, I practice in Texas, so I can't really advise you from another state.